Hello people, we'll be starting with section 31, that is election petition. So we have already seen that whenever anyone is dissatisfied with the election result or anything, then they have to file an election petition only. They cannot approach to any civil court directly. So who is the authority they have to approach? They have to go to the district judge who has the territorial jurisdiction over the particular municipality within a time frame of a 1 month. They have to apply, it won't be entertained later. The reasons could be many for an election petition. So first of all, if they think that the person was not qualified at the first place to be in the candidature list, then if the person was involved in any corrupt practices under section 9, then they think if the nomination was improperly rejected for some other person or the nomination was improperly accepted, if they think that the result was improperly affected because of the improper acceptance of nomination or refusal or rejection or acceptance of vote in a wrong way, or if any corrupt practices were involved, or if the petitioner or the candidate or any other candidate only, these two person can only apply for election petition. So if any of these have considered that they received the majority of the votes, if the corrupt practices would not have been followed, they would have won. In such cases, they can file an election petition to the district judge. Section number 32 talks about the appeals. So in case of district judge decision is not considered suitable to any party, they can make an appeal to the High Court, and that too within a time frame of 30 days. Although the High Court could entertain it later if it considered that some emergency was there. Then if there is any order which is declaring the whole election to be void by a district court, then High Court can reverse the order. It could, and the order is not applicable for that much of time. High Court has to try to solve the election appeal as soon as possible and give it the final result within 3 months maximum time. Section number 33 is about the procedure when election of all candidates is set aside, that High Court or District Court has declared, and that order is final, that all election was void, and such application by section 31 or section 32, that is District Court or High Court have declared. So in such cases, if all or more than 2/3 of members are declared disqualified, in such cases dissolution can be done by the state government. So state government can dissolve the municipality under section number 322, which we are going to read very late yet. But the purpose is to dissolve the municipality and conduct election. Section number 34 is about the finality. It talks about that in case appeal was made to High Court and High Court has given a final order, then that is the final. If no appeal was made against High Court, then District Court's order would be final. So the finality of order and decision is discussed in section 34. Section 35 is about the disqualification. While discussing the disqualification, you must also remember that we have already discussed the disqualification in section number 14 and section number 24. So section number 14 was about disqualification in electoral rolls. Section number 24 was general disqualification for membership, and section number 35 is disqualification for membership when you are elected. Now, what are disqualification here? Disqualification if you are involved in any electoral offences, which we have discussed in section number 22, where Representation of People of India Act was considered, and corrupt practices, which we have discussed in section number 29. So any person who is disqualified according to these two laws, according to these two sections, would be disqualified, and it could be disqualified for 6 years from the cases of conviction, from the date of conviction. Now coming to section number 36, which is period of disqualification. So the period of disqualification of a member can be reduced or it could be removed by State Election Commission only. State Election Commission will give in records in writing that because of these reason, this period of disqualification of the member has been reduced. Section number 37 is about the oath of office. So the oath is to be taken by the members before any officer who will be authorized so by state government within a time limit of 1 month from the first sitting. If the person doesn't take oath within this much of time limit, they are considered to vacate their seat, except when they are in jail for some reasons. Section number 38 is about the resignation. So in case a member wants to resign, then they have to do this by a written notice, which is to be given to the chairperson, and this notice has to be attested by an executive magistrate and has to be submitted. Now, when the resignation will come into effect, it will come into effect after 15 days or when the chairperson accepted. So, whichever date is earlier, the resignation will come into form from that date. Section number 39 is about the removal. So, removal of members. If any person is absent from a general meetings for more than 3 consecutive meetings, then the person would be removed. If the person is unable to take the oath within the time frame, we have just discussed the oath in section number 37, then the person could be removed. If he is disqualified after being elected, so after election, if he is disqualified under 14 or 24 or 21, then he stands to be removed. And conduct. Now, if the person's conduct is such like if he deliberately neglects duties or misconduct or do some disgraceful conduct or is incapable of his duties, abuses his position, in such cases also the uh, removal could be proceeded. How the removal would come into picture? So first of all, the inquiry by a state government would be ordered. State government will ask some officer who should not be on any rank lesser than a state level service. So inquiry would be done by that officer, and the member would be given a opportunity to explain what were the reasons. How the knowledge will come about about all these things? It could state government can start on its own. It could come from any knowledge, or the municipality can ask the state government to do so. Now, once the inquiry has been started, the charges are framed. The state government will frame the charges and send them to a judicial officer. The judicial officer is also appointed by the state government. Now, this judicial officer will have the power of a civil court. Judicial officer can summon, can ask the person to give an oath, can ask him for evidence or any other document as he deems fit, and make his final conclusion about the things and send it to the state government. State government can further ask for re-inquiry also and accordingly proceed further. Now, after that, state government will take its action. That is, state government can suspend the particular person, and the person won't be able to take part in the meetings or anything as a member of the municipality. And such final orders have to be placed published in the official gazette of the state as soon as possible. Now coming to section number 14, which is inquiry after term. So we have just seen that in section number 39 there were some reasons for removal. So all these absent and relating to oath and disqualification will only be possible when the member is in position. If the member has been not a member now, then only the conduct is the reason left for the inquiry. So in such cases, the inquiry could be taken up later also. So, the allegation after expiry of term of office are also taken into account. The person could be suspended if he is still in the office, and like if he is re-elected, and the inquiry could be taken with the necessary changes which are required according to the time. Section number 41 is about the disability. Now, in case if a person is removed under section 39, we have just seen section 39, different reasons. If the person is removed after the inquiry, then he is not eligible for re-election from the from the date of order of removal or the date of adverse finding for 6 years. Then section number 42 is about the restrictions on holding simultaneous positions, like a member could not have a membership of a municipality and state legislative assembly or a parliament like Lok Sabha or Rajya Sabha or PRIs, that are Panchayati Raj institutions. A member cannot have all of these membership at the same time. So a member has to either resign from all these positions or otherwise he will cease to be the member of municipality. So this has to be done within 14 days before the expiration of 14 days. Now, section number 43 is that every municipality has to have a chairperson and a vice chairperson. So, what will be the designation? As we have seen in the earlier classes, there would be a chairperson and a vice chairperson. So, chairperson of a municipal corporation would be called a mayor, and vice chairperson would be called a deputy mayor. Chairperson of a council would be called a president and vice president, and chairman and vice chairman. So these will be their designation, and every municipality has to has a chairperson and a vice chairperson. Now, what will be their term? The term will be as per the term of the municipality. The chairman seats should be reserved also for the SC, ST, OBC or women. The reservation should be there and which should be distributed properly. So in case of absent, if the chairperson is absent for 1 month or more than 1 month, then he is considered to be vacating his position. Although the chairperson can take a leave up to 6 months, so if he is absent without a leave granted from municipality, then he is considered to vacate his seat. In case of absence of chairperson, it is the vice chairperson who will take the chairperson's powers and duties. Now, if there is any resolution for vote of confidence or any kind of removal proceeding, in such cases, the chairperson or vice chairperson has considered to vacate their positions. They could also be suspended. Resignation, the chairperson, vice chairperson has to give it to the chairperson, and the chairperson has give the resignation letter to any officer who is appointed or authorized so by a state government. In case of re-election, the remainder of the term would be considered, and chairperson would be allowed for some monthly allowances from the municipality fund. Then section number 44 is about validity of election. So now we will see that how to determine the validity of elections of chairperson or vice chairperson. So in such cases, an election petition has to be filed, and election petition will be filed by a defeated candidate or a candidate whose nomination has been rejected, and they have to make a deposit of 1000 rupees. So they will submit this election petition to the district judge, and district judge will look into the charges. If district judge find the complaint to be frivolous, then he can forfeit this amount submitted. Section number 45 is about the core function. As we have seen in the very first lecture, what are the core functions of a municipalities, like public health and sanitation. They'll take care कि कोई disease नहीं spread हो, नालियाँ साफ हो, सड़कें साफ हो. Safeguarding and managing public property, तो वो देखेंगे कि proper fire extinguishing की services available हैं. जो भी पुरानी बस्तियां हैं तो reclaim that property. They'll make the plans, किस तरह से पूरा प्लान बनाया जा सकता है. for economic or social और poverty elevation और slum improvement या फिर PDS वगैरह से related जो भी plans हैं वो कैसे बनाए जा सकते हैं, population control वगैरह कैसे किया जा सकता है, they'll take care of the roads या फिर कोई lighting वगैरह करानी है, beautification like parks वगैरह बनाने हैं या कोई fountain वगैरह लगाने हैं, कोई भी जो data है they'll keep the statistics for community, sports and culture किस तरह से बढ़ाना है वो और जो भी फिनेंसेस हैं कोई भी डेवलपमेंटल वर्क के लिए जो भी फिनेंसेस अवेलेबल है तो उनका डिस्क्लोज करना कि हमने कहाँ पे कितना पैसा लगाया है क्रूलिटी टू एनिमल्स को भी प्रिवेंट करना सो दीज आर द वेरी कोर फंक्शंस ऑफ म्युनिसिपैलिटी जो उनको करने ही हैं then there are some provision like अगर municipality doesn't have enough capacity like managerial technical financial या फिर organizational capacity नहीं है depending upon that capacity they can take up or postpone any of the functions which we have just seen or state government can also ask them to take up or postpone any of these functions depending upon their capacity then municipalities can also give some work to different agencies under section number 154 to plan or build or operate or maintain or manage anything like that it can do so. Coming to section number 46 which is other function. Now after the core function has been performed if the municipality has enough funds to take up more functions it can do so depending upon again their managerial technical financial or organization capacity so these are the function like environment protection तो इसमें क्या होगा कि social forestry करें nursery बनाएं greening करें और या फिर civic culture मतलब flowers वगैरह उगाने वाला बढ़ाएं एंड देन पब्लिक हेल्थ एंड सैनिटेशन की अगर बात करें तो जैसे कोई मास कैंपेन करे वो कोई इन्फेक्शियस डिजीज को इरेडिकेशन के लिए या फिर पब्लिक टैंक्स वगैरह को रिपेयर करे सेमिनार लगाएं टू इंक्रीज द सिविक कॉन्शियसनेस देन एजुकेशन एंड कल्चर की बात करें तो जैसे वो कोई भी तरह की एजुकेशन जैसे सिविक एजुकेशन या सोशल एजुकेशन नॉन फॉर्मल एजुकेशन को बढ़ावा दें म्यूजिकल इवेंट्स ऑर्गेनाइज कराएं फिजिकल एजुकेशन के लिए कुछ इवेंट्स ऑर्गेनाइज कराएं थिएटर्स करवाएं और वो लाइब्रेरीज बनवाएं पब्लिश देयर ओन जर्नल्स स्टैच्यूज इनफैक्ट बनाएं आर्ट गैलरीज जूलॉजिकल और biological gardens बनाएं conservation करें any place of historic and artistic importance to them then public welfare like in provide homes to destitutes या फिर during floods आ जाए या अकाल पड़ जाए तो they provide them shelter और maternity और child welfare के लिए कुछ provisions करें स्केवेंजर्स की रिहैबिलिटेशन के लिए करें या फिर कोई भी तरह की इंफॉर्मेशन डिसेमिनेशन के लिए वर्क करें फिर कम्युनिटी रिलेशन बढ़ाने के लिए दे आर द वन हु हैव टू गिव द सिविक रिसेप्शन टू एनी पर्सन ऑफ डिस्टिंक्शन ऑल्सो टू पे होमेज ऑन डेथ ऑफ एनी डिस्टिंग्विश्ड पर्सन और वो फेयर्स भी ऑर्गेनाइज करवा सकते हैं और एग्जीबिशंस भी लगवा सकते हैं सो दीज आर द अदर फंक्शंस apart from the core function if the municipality thinks that it is capable enough it can do so then next is section number 47 these are the functions assigned by government now state government can assign any further function to municipality depending upon their capacity if state government thinks fit that it is necessity and the municipality has enough resources then state government can assign these functions to municipality section number 48 is functions of chairperson so the chairperson and vice chairperson also so the chairperson's functions are like chairperson has to convene meetings under section 58 which we are going to do very soon and they have to conduct the functions of the house that is they have to preside and regulate the meetings finances like they have to watch over the financial executive administration of the municipality or any other function which time demands them to do then vice chairperson will have to exercise the power and perform duty as delegated by chairperson to him and he has to preside over the meetings when chairperson is absent. Section number 49 is chief municipal officer So Chief Municipal Officer's powers and duties are mentioned in section 49. So first of all, what are his duties? So he has to keep the record. He has to have the custody and maintenance of all the records of the municipalities. Then he has to advise the municipality during any meetings. If he find that some provision, something is taken up which is not in interest of municipality, then he has to tell so. And if he doesn't, if he deliberately forgets, knowingly doesn't do that, then he is liable. The municipality can make him liable for this and pay for him and extract as per the rules. Then he has to authenticate all the resolutions or licenses or permissions which are from the municipality. He has to maintain the correspondence with the state government. He has to be responsible for the furnishing any proceeding and documents which are required by the state government. He has to be responsible toward that. Then he has to take care that there is no irregularity in audits and account. If there are, he has to correct them. He has to report regarding any fraud or theft or loss of municipality. He has to supply for, if municipality asks him about any report or document or statement, then he has to supply that. He has to provide explanation when in discussion on any thing in the municipality. He has to explain, but he don't have any right to vote, and he cannot vote, and he cannot make any proposition that ye karo wo karo. He just explain what could be done and how could be done. He cannot make the final proposition. He has to execute all the welfare related things and have to execute them speedily. He has to supervise जो भी उसके नीचे staff काम कर रहा है. He has to supervise all of them. Although the overall supervision is under the chairperson itself, but he has also, if and any other function as provided by the time and as government may think fit. Now coming to section 50, that is handing over the charges. Now in case of any resignation, removal या फिर suspension या फिर office में नहीं है, तो who will take of the charges of these political positions? Now in case chairperson अगर नहीं है, तो vice chairperson will handle the charges of the chairperson. अगर वाइस चेयरपर्सन भी नहीं है तो स्टेट गवर्नमेंट किसी को भी दे सकती है ये फंक्शंस. एनी स्टेट गवर्नमेंट में डीम फिट. One thing is to be taken care that in case of reservation, the state government has to look for a reserved category person for the position. अगर नहीं मिलता है, then state government can give it to anyone. Now, if vice chairperson is not there, the chairperson will be taking care of these functions. If the vice chairperson or chairperson भी नहीं है, तो again state government can give it to any person. Now coming to the members, if members are not there, then also the charges are to be taken by the chairperson itself. Now, if the municipality is dissolved, now in such cases, a newly elected municipality will be taking the charges, or if this is not possible, then the state government will decide that a officer under this section 352, which we are going to read later, will handle the charges of the respective thing. So that is all for today. Chapter number 2 has been completed. We'll be starting chapter number 3 tomorrow. See you tomorrow.